This is an embarrassment to the South African law proceedings that at this stage, during trial, we are still dealing with this kind of an application. An issue, my lord, which ought to have been discussed at a pre-trial conference stage before we started with this trial. My lord, procedurally, it is the duty of the state to consult with all the witnesses, state witnesses, before the trial starts, in order to ascertain issues like of this nature that we are facing today.
Yes.
My lord, we ought to have been informed by the state at the beginning of this trial, after realizing that the media has been allowed to broadcast these proceedings, that yes, the state does not object the broadcasting of media, but on conditions of the following witnesses who might be affected by this application.
Can you really say that? Because Advocate Baloyi said it clearly, that last night he received an email or whatever he received.
My lord, I'm still coming there. I'm just stating the procedure, what ought to have been done by the state at the beginning. That ought to have been canvassed with all the witnesses, my lord, who will be adversely affected by the broadcasting, so that this court will know that there are exceptions to other state witnesses like this one, and maybe other witnesses, if there are any, we don't know. We have not been informed. We ought to have been informed that this broadcasting is accepted but subject or with the exceptions to the following witnesses. Coming to this case, my lord, yes, I agree, my lord, that the state has indicated that they were only informed last night. Why only yesterday? Why only on the last hour? Because during trial preparation, the state ought to have been informed of this objection.
Yes.
Secondly, my lord, after the state had known or had been informed of this application, we were never informed as the affected parties. Via the email, my lord, the state had the whole night to prepare this application. And we are now being ambushed by the state to read and prepare our responses, wherein we're negatively affected by the application. That is unfair, my lord. Secondly, my lord, coming to the reasons stated by this special witness, who says because of a personal safety.
Is that a designation, special witness?
Oh, my lord.
I don't want us to use this process to ridicule anyone.
My lord, can I just withdraw that? Can I just withdraw that?
Yes.
Thank you, my lord. He says he's bringing this application for her personal safety.
Yeah.
Our lives, my lord, I mean the court officials, by our court officials, accused persons, all our safety has been compromised by the broadcasting, my lord. But we have allowed it to proceed because we were respecting the court order, my lord. And we also understood that the freedom of expression also allows the media to broadcast the proceedings.
Yes.
And the second point, my lord, that has been raised by the state is the concern about the public comments and public opinions, whatever that is, will be raised or can be raised after her testimony, comparing her testimony with other witnesses and so forth, as it has been stated by the state, my lord.
Yes.
That has got no adverse effect to this court. This court is not bound, my lord, by the public opinions, by public comments, by public critics, my lord, of any sort. This court, when deciding or when deciding on this matter, will be bound by the evidence presented before this honorable court. In other words, my lord, it will have no adverse inference to this court if her evidence is broadcasted as we have been doing. Secondly, my lord, the issue of safety. I myself, as the defense counsel for accused number 5, had been posted on Instagram and all social medias by the same witness, my lord. And I will ask this court to adjourn right now so that I print all the statements that this witness has made about myself, my lord.
Is that on point? Is that on point here?
It's part of my address, my lord, because the issue of personal safety has been raised, my lord, by the state. So I'm saying, my lord, if we were to consider the personal safety of this witness in isolation, what about the personal safety of other people, including myself? And I cannot make those submissions without presenting those pictures before this court as a self-evidence, my lord, that my safety also as well has been compromised. But I'm proceeding with the trial. And I will be making submissions to ask this court not to consider that fact in isolation, but it must consider it in respect of all other people. The pressure as well, my lord, that has been stated as another reason that broadcasting will put pressure on her. What kind of pressure, my lord? It has not been placed before this court. How? The nature of extent of the pressure, the prejudice. In what way, in what sense will pressure? Because, my lord, this is a person of a public figure. This is a person who is known by everyone. This is a person, my lord, who has been posting herself on her pages of social media about this case. And then if today he's saying that he will encounter pressure or suffer pressure, in what way? That had to be placed before this court. This is not a person who is foreign to media language. He's a fan, instead, my lord, of media usage. And then, further to that, my lord, the issue of Netflix documentary, I know the court is not aware of that document, my lord. But, my lord, this is a document wherein this particular witness had participated to it, my lord.
Did you hear what I said about Netflix when your colleague?
Yes, yes, my lord.
Yeah.
Yes, my lord.
I'm saying that does not lead only to one conclusion.
Yes.
The one conclusion, which is what you and advocate, the representative of accused number 3 said, is that she can do it, she has done it. and nothing happened to her. I think that is what you are saying, after she did it. But I'm saying, yes, that is the one side of it. The other side of it could be that out of participating in that Netflix or whatever, yes, there could have been other developments.
Exactly, my lord. That's where I am.
Yes.
There is no evidence there which has been placed before this court to say, as a result of her participating on the Netflix, this is what she has suffered.
Yes.
We have no evidence. Instead, what we know is that she has been paid for participating. She benefited without any prejudice. And now today, she says she will suffer prejudice. And that document, my lord, the Netflix documentary, is published, is circulated to everyone. She has testified, she has said a lot about this case, my lord. And she never asked any limitations of maybe her face or visual not being recorded in that documentary that is being circulated, my lord. Now, when we are dealing with a case, my lord, wherein this court is supposed to listen to the evidence of each and every witness in order to decide on this matter. Netflix, my lord, benefited and had no duty to make any decision. But this court, which is seized with such a crucial duties of determining as to who actually killed the deceased, then we are confronted with this application. My lord, it is my submission that this court should not entertain that application. This court should not grant the application. We understand for the issue of safety, like the first and the second previous witnesses, their faces have not been shown. Let's proceed.
I think you should. I think you are not putting it correctly. I don't think I can take it from where you're saying I should make no considerations of safety, because that would, if I were to do it, it would even be discriminatory. Because when an incident took place which seemed to border towards placing the safety of Tumelo Madlala into jeopardy, yes, this court intervened. I even, yes, cleared this courtroom, yes, of some of the individuals who seemed to be implicated. Yes. That was subsequently dealt with the journalist, and we arrived at a very firm understanding that whatever we do, we should not deliberately, or if we can help it, place, yes, anyone safety in jeopardy. Yes, so I cannot today say no, I no longer care about the safety of anyone.
My lord, I'm not necessarily saying this court should not take care for the safety of the witnesses. But I'm making submissions to say, my lord, this court has entertained the safety of the witnesses to such an extent that Mr. Madlala and Mr. Twala, their faces, it was an order of this court that their faces should not be visualized in the interest of their own safety, which is the precedent that has been created before this court, of which I ask with due respect that should also continue with the next witness. The only issue, my lord, that I'm raising, that I'm asking this court to consider regarding this witness now, who is asking more than what has been ordered by this court, is that if she is genuine about her safety, she ought to have considered that first when she went on Netflix. If, my Lord, this witness was genuine and sincere about her own safety, she should not have posted herself on media platforms, my Lord. As I've said, my Lord, I'm asking for a short adjournment so that I'll print those images to show the court, to support my point, my Lord, that I'm submitting before this court. I'm not saying this court should not consider, but I'm just putting it as a point of consideration before this court.
Yeah, well, it brings me to a point I was to raise later, that it's coming to where everyone will have to come up with concise heads about it, whilst we wait for the media, because I don't know when the media will be coming. There is encouragement. I think it started with Mr. Ramsipidi for the court to rule that there be audio beaming, yes, and that we proceed. But then Advocate Baloyi assures us that it is part of what is objected to.
Yes.
If it is objected to, I have to listen to both sides and then come up with a ruling.
With a ruling.
Yeah, I think there will be a bit of a cart before the horse if we now start to make a ruling about these proceedings when there is an objection about how they are unfolding.
Yes, my Lord. My Lord, maybe before we adjourn, can I just include one point? So my Lord will note that I haven't finished with my submissions.
Yeah, I was also to say that
yes.
Although I don't know whether the postings done by this witness will take the point any further, if you were to strongly want to do that, I think it will be part of your written arguments.
Part of, my Lord?
It will be part of your written arguments.
Arguments,
yeah.
As the court pleases, my Lord. So it means that, my Lord, it means I will have to pause here, or should I proceed? And
I think you should argue everything except that I'm saying that it has come to where I think everyone should come up with concise heads whilst we wait for the media representative. Yeah.
And obviously, my Lord, we won't be ready with the concise heads of arguments today. Mm-hmm. Definitely, my Lord. Okay. I don't know, my Lord. I personally won't be ready with the heads of arguments after lunch today.
Yeah. Because some of you have been quoting passages here, and
yes,
I think it will be best if I have it in written form before me.
As the court please.
Please the court. I think there's a